coming to the main topic, which is the types of jurisdictions which are exercised by the Supreme Court. So broadly, Supreme Court exercises original jurisdiction. I will deal with each one of it and then roughly tell you what are the categories of cases which come under each of these jurisdictions. So one is the original jurisdiction. Second is a writ jurisdiction. Third can be called as an appellate jurisdiction. Then you have extraordinary jurisdiction, which is exercised by the Supreme Court. Supreme Court also exercises advisory jurisdiction and inherent and plenary jurisdiction. So broadly, these are the different jurisdictions which are exercised by the Supreme Court. Now, I just broadly take you through each one of these jurisdictions. In fact, if we have to talk about each jurisdiction, 1 hour for each jurisdiction will be required to try and explain each detail of that jurisdiction which is exercised. But today I will just try to endeavor to just broadly tell you what are the different kind of category of cases which may fall under each of these jurisdictions. As I told you, the first jurisdiction can be called as a original jurisdiction. Original jurisdiction can be said to be the court where the case is filed as the first resort. Like for instance, if there's a civil suit between two parties, the lowest court is where it is filed. It's called a civil court or wherever, is where the proceedings would usually be filed. A similar jurisdiction is also exercised by Supreme Court. The Supreme Court also exercises original jurisdiction where the disputes are filed as the first resort. So that's covered under Article 131 of the Constitution. So it confers exclusive powers to the Supreme Court to adjudicate the following dispute as a court of first resort. So when I say exclusive jurisdiction, which means the kind of disputes which are laid on under Article 131 can be decided only by the Supreme Court and not by any other court. So to give you an example, the first bullet point you will see disputes between Government of India and one or more states. Second, dispute with the Government of India and one or more states on one side and one or more state on the other. Dispute between two or more states, if and insofar as the dispute involves any question whether fact or law on which existence of a legal right is dependent. So, any dispute between the Government of India and one state, or the Government of India and some state on one side and another state on another side, or between two states, those disputes can be decided exclusively by the Supreme Court. So usually you will find all the river water disputes between two states are usually suits are filed in Supreme Court. Though there are certain tribunals which are constituted, you will find original suits being filed in Supreme Court when there are disputes between two states. And there have also been instances where the union government has come out with a statute and some state government has challenged the validity of that statute under Article 131 by filing an original suit in the Supreme Court. So these are the kind of cases where the Supreme Court exercises original jurisdiction. And in case of High Court, the High Court of Madras, Bombay, Calcutta, Delhi also exercise original jurisdiction. So to say the suits are directly filed in these high courts, subject to what is the jurisdiction which is conferred on them. So far as the Supreme Court is concerned, the original jurisdiction is conferred on these for these disputes which I just explained. Apart from that, the following cases from the heading says also includes these are also cases where the petitions are directly filed in Supreme Court. The first one being transfer petition, which is under Article 139 of the Constitution. You'll find a lot of these transfer petitions in the Supreme Court. Once if you're interning somewhere or when you come to practice in the Supreme Court, you'll notice a lot of transfer petitions are filed in the Supreme Court. So what is a transfer petition? Say for instance, in a lot of matrimonial cases, once there is some dispute between the couple, it may so happen that one person, be it the husband or a wife, goes up to another state. But the husband would have, to give an example, the husband files a case in say, Cochin, but the wife is now residing in Chennai. So the wife finds it very difficult to travel from Chennai to Cochin to contest the case all the time. And the wife has also filed certain cases against the husband in Chennai. And if the wife feels, instead of having two cases in two different places, everything should be tried in one place. So the Supreme Court has the power to transfer case from one state to another state. So it is only the Supreme Court which has the power to transfer a case from one state to another state. So therefore, transfer petitions are filed in Supreme Court seeking transfer of one case to another state. And other situations, the Supreme Court can also transfer, like for instance, if there is the challenge to the validity of a particular statute, there is central legislation which is pending in all different high courts. And if the court feels that instead of all the high courts taking different view, let us transfer all these petitions to one particular court. There have been so many instances where all those petitions are transferred to one particular high court and a direction is issued to that court to decide those cases. And the court has the power to transfer it to itself also. So that's the transfer jurisdiction which is exercised. It's the original jurisdiction, but to transfer cases from one state to another state. This is under Article 139. You have these election petitions. So the challenge to the presidential and vice presidential election lies to the Supreme Court. Then thereafter comes the arbitration petition. So arbitration appointment in international commercial arbitration for the appointment of an arbitrator, petition directly has to be filed in the Supreme Court. Next, we can say the writ and writ jurisdiction, the PL is exercised by the Supreme Court. I'm sure you must be aware of the distinction between Article 32 and Article 226. Article 32 is the power, is the right to approach the Supreme Court if any of your fundamental rights are violated, which is conferred on every citizen. So the Constitution under Part 3 has guaranteed certain fundamental rights to the citizens and the persons within the country. The writ jurisdiction of the Supreme Court under 32 is in the nature of a guardian of fundamental rights. Under a writ jurisdiction, a person can directly move the Supreme Court for the enforcement of the right which is conferred under Part 3 of the Constitution. The Supreme Court also entertains public interest litigations under 32, which are also in the form of writ, with the difference that there are more relaxation on the rules of locus when it comes to a PIL, and the procedure and is not treated as an adversarial litigation. I'm sure all of you know what a public interest litigation is. The Supreme Court also exercises. And also, you must be reading a lot of articles where different PILs are filed, and the court decides whether they should entertain any of those PILs or not. So that's a jurisdiction which is exercised by the Supreme Court. Then you have the appellate jurisdiction. Appellate jurisdiction meaning an order of a court below is the validity of the same is challenged before an appellate court, and the Supreme Court exercising the appellate jurisdiction decides certain disputes. Now I will try and explain what are the different kinds of cases which are decided by the Supreme Court by exercising its appellate jurisdiction, not the original jurisdiction, by the appellate jurisdiction, being a court which is superior than another court deciding cases. But I may not be completely right in saying a superior court, because certain high court orders are also decided by the Supreme Court by exercising high court appellate jurisdiction. Both are constitutional courts, and one is not superior to another. So technically, it may not be that every high court decision is challenged for the Supreme Court. The Supreme Court exercises an appellate jurisdiction. So it may not be completely right to say that. I'll just tell you, exercising the appellate jurisdiction, what are the cases considered by Supreme Court? Article 132, 133, and 134 of the Constitution generally deals with the appellate jurisdiction exercised by the court. The first bullet point. I will just read that out and try and explain what it is. An appeal lies to the Supreme Court from the High Court in a civil, criminal, or other proceedings where the High Court under Article 134A certifies that the case involves a substantial question of law as to the interpretation of the Constitution. This is what Article 132 says. If the High Court, be it in a civil or a criminal case, certifies that the case which is being certified involves a substantial question of law as to the interpretation of the Constitution. So in that case, there should be a question which is a substantial question, which involves the interpretation of the Constitution. So it has to pertain to the interpretation of the Constitution. Under Article 132, the High Court can certify that this is a case which is fit to be decided by Supreme Court. So you must keep in mind, Supreme Court being the apex court, it's not as if all cases reach Supreme Court and Supreme Court must mandatorily decide all of those cases. So this appellate jurisdiction is something which is very important because the court is exercising its appellate jurisdiction, and they sort of deem that the duty bound to decide those cases because the High Court, like for instance in Article 132, the High Court is certifying that the case which they are certifying involves a substantial question as to the interpretation of the Constitution, maybe regarding a particular provision or a particular article of a Constitution. The High Court feels that this is decided by the Supreme Court, they may certify, and the Supreme Court exercises the appellate jurisdiction and decides that. Now, coming under 133, it's a civil appeal under 133, lies against the judgment of any High Court order, which involves a substantial question of law of general importance, or which is the opinion of the High Court. The said question needs to be decided by the Supreme Court. So this is also being certified by the High Court, but this is not regarding the interpretation of the Constitution. When it comes to the interpretation of the Constitution, it's under 132, Article 132. 133 pertains to any substantial question of law about of general importance. Need not be Constitution, could be under any statute or any other provision. So if it's of a general importance, then the High Court can certify. Next is Article 134C. In criminal appeals under 134 lies against a judgment by the High Court, where on appeal it reverses an order of acquittal and sentences him to death, withdraws from a subordinate court any case, and convicts an accused and sentences him to death, or certifies that it's a fit case for appeal to the Supreme Court. So far as criminal cases are concerned, two categories of cases. One, if the High Court certifies that there's a fit case, then an appeal lies. Or in a criminal case where the trial court has acquitted a person, High Court in appeal has reversed that acquittal and held that person to be guilty of an offense and imposed either a death sentence or a sentence more than 10 years, a death sentence or life sentence. Such cases, an appeal will lie to the Supreme Court. So such cases will be a civil appeal. Any case under the appellate jurisdiction will either be a civil appeal, numbered as a civil appeal, or a criminal appeal. Next, you'll find, apart from this appellate jurisdiction of the court, which we have said articles, under certain statutes, appeals are provided to Supreme Court. To give you an example, under the National Grain Tribunal, so any order passed by the National Grain Tribunal, an appeal will lie to Supreme Court. Any order passed by the National Consumer Dispute Resolution Commission exercising the original jurisdiction, an appeal will lie to Supreme Court. Against National Companies or Appellate Tribunal, an appeal will lie to Supreme Court. So there are different statutes under which an appeal is already provided to Supreme Court. An order which is passed by those tribunals under those statutes, an appeal will lie to the Supreme Court, which is prescribed under those statutes. In those cases, while Supreme Court is exercising the appellate jurisdiction. Next, we have this advisory jurisdiction. This is covered under Article 143 of the Constitution. It provides that if any time it appears to the President of India that a question of law or a fact which is arising or is likely to arise, which is of such a nature and such public importance that it is expedient to obtain the opinion of the Supreme Court upon it, the President can refer the matter to the court. So it is the court seeking the opinion of the court, the President of India seeking the opinion of the Supreme Court on any issue or a fact which is already arising or which is likely to arise. So that is called the advisory jurisdiction. So that's why the President of India is seeking the opinion of the Supreme Court. So that is the advisory jurisdiction which is exercised. Next, you have the extraordinary jurisdiction. 99, I can confidently say 95 to 99% of the cases in Supreme Court fall under this category. So, as we must have already seen, the appeal is provided only in very limited cases. It's not as if, for instance, we never said every order passed by the High Court is not appealable to Supreme Court. There are limitations which are prescribed. So it is not as if the Supreme Court sits as an appellate court and decides every order which is passed by the High Court or by the tribunal. So, but the Constitution provides that even in such cases, in extraordinary circumstances, a litigant can still invoke the jurisdiction and file a petition, which is called a special leave to appeal, which is under Article 136 of the Constitution. So a person, though an appeal remedy is not available, can file a petition under Article 136 and request the court that there is a substantial question of law which is involved in this case, which is going to have a wide impact. So grant me leave to appeal. That's why it's called a special leave to appeal. So you're seeking leave of the court to file an appeal. So these petitions are usually called special leave petition, SLP in Supreme Court. So special leave civil category is SLP civil, criminal category of cases comes under SLP criminal. So in criminal cases, SLP criminal is filed. So you're seeking the leave of the court that please permit me to file an appeal. I don't fall under the category of 133, 134, 135 that you saw. So, but I think this is a case in which there is a substantial question which is involved. So please invoke your jurisdiction and correct the error. So therefore, you file a petition under 136. As I told you, majority of the cases in the Supreme Court fall under this category. And these days, because of the ability of persons or the resources which they have, they don't want to stop fighting their cases to the Supreme Court. I'm sorry, it is a High Court. They would still want to take a chance before the Supreme Court. So because though an appellate remedy is not eligible, they end up filing a special leave petition. These cases come up for admission hearing on a Monday and Friday, which I'm going to explain eventually when we deal with how the cases are dealt with. It comes up for admission hearing. So when it's an appeal, as I told you, because the court is exercising appellate jurisdiction, the court thinks that we have to consider it essentially. So they issue notice, they consider detailed arguments and decide the case. But when it comes to this extraordinary jurisdiction, the court will hear the counsel, the parties, and decide whether they should at all entertain it. So that's why most of the cases are dismissed at an admission stage. Because the court feels that it is only an interstate dispute between the parties, there is no question of law. This is not a dispute for the Supreme Court to decide. So therefore, we are not going to exercise the extraordinary jurisdiction which is conferred on us. So therefore, you will often find a lot of articles treated by judges saying that the court is overburdened with these special petitions, or anticipatory bail and control petitions are brought up to the Supreme Court. We being a constitutional court who is supposed to interpret the Constitution should not be spending time in deciding this interstate dispute. It has to come to an end by a decision by the High Court. Is something which is often said by all the judges. So though majority of the cases are under this, it doesn't mean that the court entertains those petitions and it lies in the docket for a long time. Most of these cases are decided on the very first day, and the court usually does not entertain it unless they are very convinced that there is a gross injustice which is done to the party or there is a law to be laid out. They usually don't interfere by exercising this jurisdiction. Next is the inherent and the plenary jurisdiction. This form of jurisdiction includes the following type of cases decided by the Supreme Court. One is the contempt of case. Contempt of case is when you're trying to bring down the majesty of the court, or you are grossly violating an order passed by the court exercises contempt jurisdiction. Secondly, it's called the review petition. Review is there in CPC also. It's a similar provision in the Supreme Court rules as well. So review is once the court decides and Supreme Court passes an order, decides an order. If there is an error apparent on the face of record, then a review can be entertained by the court. And as per the Supreme Court rules, a review petition is decided by circulation. So what I mean by circulation is, it is the petition is circulated to the judges who decide the case. There is no oral arguments which happens. They look at the petition. If they're convinced that there is probably an error apparent on the face of the record, they may list it for arguments and then decide. So review jurisdiction is exercised only in exceptional cases, because you can just imagine, after hearing the oral contentions of the lawyer who is presenting the entire case, the court has not been convinced and they passed an order, whatever the order be. One party who is aggrieved by it is filing a review petition saying there is some error apparent on the face of the record because you have not seen this, you have not seen that, whatever be the contention. It's not as if the court has to against it rehear the matter, because then it will be a never-ending process. So that's why they have imposed a restriction that is going to be first we will look at what your grounds are. The judges will look at it. If they're not convinced, it's dismissed by circulation itself. Next is a curative petition. The history of curative is neither the Constitution nor the Supreme Court rules provided for a curative petition. It came across through a judgment called, I think it's Rupa Hora vs. Ashok Pura. So say for instance, even after a review stage, there is some reason because of which the Supreme Court has to interfere or exercise its jurisdiction. You can't file a 32 petition against the court of that. So that the court has always held that you can't file a 32 or a 226 or a writ petition against an order passed by the same court. So then what does the court do? Therefore, it's a court-invented process called curative petition, which is later incorporated in the 2013 rules also. But there are very stringent conditions. To exercise a curative petition, a senior advocate has to certify that this is a case which falls under the curative petition category. It should be, curative, the guideline is that if a party has not been heard before the court and the court had issued notice and the court had assumed that the notice was, he had received the notice and proceeded to decide the case which is prejudicial to him, then and his review is also dismissed, then a curative petition can be filed. And to restrict the number of petitions, because otherwise if you don't start restricting, even the review stage itself is more restrictive because it's only by circulation decided. Curative is even more stringent. To ensure that not every litigant comes and files curative, a senior advocate has to certify, and an advocate in record also has to certify that this falls under the law laid down under curative jurisprudence, and it falls under the categories which are prescribed, and therefore it's a fit case for being considered as a curative. And the curative is decided by the three senior most judges of the Supreme Court and the judges who decided the matter. So technically, it's mostly the 5 judges of the Supreme Court who decide a curative petition. It is only in exceptional cases that a curative petition has been entertained by the Supreme Court. It just came to my mind when I was trying to explain it to you. You will find that there was, in arbitration, there was a recent judgment by a 5-judge bench called N.M. Global. It dealt with an interplay between an arbitration and the Stamp Act. Against this 5-judge bench decision, a curative petition was filed and it was listed before the 5-judge bench, which 5-judge bench had referred it to a 7-judge bench. And this 7-judge bench had heard arguments in the last 2 days. These are available on YouTube also. So I would request all of you to just go back and watch those videos, especially the argument raised by Mr. Shyam Diwan. He had argued it yesterday, and it is towards 12 o'clock or so he started arguing. He had raised this contention about the jurisdiction which is exercised by the Supreme Court. So he had argued that the matter being placed before the 7th bench is not valid as something which he had argued. So he had explained as to what is the jurisdiction that you are invoking right now is a point that he had argued. So, but keeping all of this now, you have an idea about the different jurisdiction which is exercised by the court. I would request all of you to just hear that argument because I think it's a beautiful argument which was raised. Because he was criticizing the fact that a decision of a 5-judge bench being placed before another 5-judge bench in a curative petition has been referred to a 7-judge bench. So a 7-judge bench is not exercising an appellate jurisdiction over a 5-judge bench. So this is not the way a case is to be placed before a 7-judge bench, and heard is an objection which he had raised. So this being a fresh case which is happening before the Supreme Court, and it's also available on YouTube and the Supreme Court website, I would request all of you to just go watch to understand the nature of objection which was raised, because I think it is very beautifully raised by Mr. Shyam Diwan. Now, I've told you what are the different jurisdictions. It's based on these jurisdictions that the cases are classified in the Supreme Court. So now I'm going to tell you how the cases are classified. There are various classifications of cases before the Supreme Court. 1, petition for special leave to appeal. I told you about the extraordinary jurisdiction under 136. So it's a petition for special leave to appeal. It's called SSP. Then you have civil appeal. Appeal by certificate, appeal on grant of special leave to appeal, statutory appeals. Article 132, 133, etc. that we saw. It's a civil appeal. Then you have contempt petition, civil and criminal. We saw the plenary jurisdiction which is also exercised, which is the contempt petition, if it's civil in nature, civil or criminal. These petitions are called contempt petition, either civil or criminal. Then you have the criminal appeal. We dealt with that also, where the trial court acquittal, the high court reverses it, then appeal would write to the Supreme Court. That will be numbered as a criminal appeal or certified by the High Court. The original suits under Article 131 is called an original suit, numbered as an original suit. The petitions under Section 11 of the Arbitration Act is called arbitration petitions. You have the election petition, challenging the presidential, vice presidential election. The special references, where the opinion is sought by the court, is a special reference. The transfer case and the transfer petition. The transfer case is when the Supreme Court has to transfer it to itself, etc. transfer petition from one state to another state, which is dealt with under 225 CPC, 406 CRPC, etc. Then you have writ petitions under writ petition. So a petition under Article 32 is numbered as a writ petition. Even a PI is also usually numbered as a writ petition. Review petition, then curative petition.